I think it is clear to believe in the power of ideas.
Fresh thinking of the Manhattan Institute.
I'm Jim Copeland, and I'm the director of the Center for Legal Policy at the Manhattan Institute. It's my pleasure to welcome you to this exciting debate we've got here, kicking off, for the Center for Legal Policy anyway, kicking off our fall season here at the Manhattan Institute. Before I begin, I'd like everyone to please turn off cell phones and beepers so you don't disturb our panelists and your fellow guests. And I'd also like to let you know that those of you who are Center for Legal Policy regulars or not may be interested in coming to our next Center for Legal Policy event next week. That's Wednesday morning, and we're hosting an exciting program on our Proxy Monitor project. This is a corporate governance website we've set up. I've got a new report with lots of findings on shareholder activism and corporate governance. We're going to have former SEC Chairman Harvey Pitt there, as well as Bill Allen, formerly of the Chancery Court of Delaware, and some interesting corporate folks and folks that are involved in this process. So please check with me or the event staff here if you want to come next Wednesday morning to what promises to be a special program there. Our program tonight involves what is arguably really not arguably, the most sweeping piece of social legislation to come down, at least since the mid-90s welfare reform, but certainly arguably since the creation of Medicare and Medicaid in the 1960s, and that is the Patient Protection and Affordable Care Act, which is commonly known, or known at least to its critics, as Obamacare. And as all of you are aware, there are numerous constitutional challenges on various grounds to the Patient Protection and Affordable Care Act going through the courts. Just 2 days ago, a district judge, a federal district judge in Pennsylvania, determined that the act was in part unconstitutional. This makes now, of the 6 federal district judges who've considered the legislation, the 3rd judge to determine there's a constitutional defect with the legislation. 3 other judges ruled the other way. The circuit courts, we've had 3 circuit courts now consider this piece of legislation. One circuit court, in a divided 2-to-1 decision, determined it was unconstitutional in part. Another circuit court, by a divided 2-to-1 decision, determined it was constitutional. And then you had a 3rd circuit court that basically punted on jurisdictional grounds, determined there was what lawyers call standing. There was no standing for the Virginia case, and there's a little more nuance there on that recent 4th Circuit decision that came out a couple weeks ago that the panelists may get into. Want to explain to people briefly what we're talking about here, because there may be some confusion, particularly among the non-lawyers in the room. These challenges are by and large challenges on what's called Commerce Clause grounds. In other words, these are challenges that say that the Congress lacks the power to do this. They're not rights-based challenges. And when you look at the era in the court's history from about 1895 through 1937, when the Supreme Court was striking down numerous pieces of legislation, they were doing it on both grounds. So you had the famous or infamous Lochner v. New York decision that determined on rights-based grounds that a Baker hours law provision in New York law was unconstitutional. That's not what's involved here. What we have here is a Commerce Clause challenging the power of Congress to enact the individual mandate, as well as certain other areas of the law, including the spending power, whether that's coercive, and things that Richard may get into in a minute. To consider these cases, and both what's happening in the courts now and maybe what ought to be in terms of our constitutional law and how we ought to think about these questions, we've got perhaps the 2 most able advocates of their respective positions in the Academy in the United States, Richard A. Epstein and Laurence H. Tribe. Professor Epstein is known to many of you who are regulars here at the Manhattan Institute because every fall when he's here in New York, he's a visiting scholar with the Manhattan Institute. His full-time position nowadays, after a long tenure at Chicago Law School, where he's still an emeritus professor, is as the Laurence A. Tisch Professor of Law at New York University School of Law. He holds numerous other adjunct positions, as well as a senior fellowship, the Peter and Kirsten Bedford Senior Fellowship at the Hoover Institution. Professor Epstein is arguably the foremost proponent of the libertarian view of law, both the common law and the constitutional law in the United States. He's going to be arguing the pro in this debate, i.e. he's going to be arguing that the Affordable Care Act is unconstitutional. Arguing the con is arguably the foremost proponent of a sort of standard left-of-center professorial academic viewpoint. And I don't mean that as an insult.
Neither did I.
And that's Laurence Tribe. Many of you, even if you're not students of the law or lawyers, will remember that Professor Tribe famously argued the Bush v. Gore decision before the Supreme Court, one of, I think it's 35 cases that Professor Tribe has argued before the U.S. Supreme Court. He also is the author of the standard sort of hornbook treatise on constitutional law. It's the treatise I used when I was a teaching assistant in constitutional law back when I was in law school as well. Universally revered expert on constitutional law. So I think we're going to have an interesting contrast of perspectives and worldviews by two people who are just uniquely equipped to carry on this debate. So with that, and without further ado, I'm going to turn things over to Professor Epstein.
Sit down. Thank you so much. I mean, it's a great honor to be here. I should give you my sort of constitutional pedigree. I actually taught the course once. I'm not sure I understood it then. And I've never argued any cases before the Supreme Court. So that when I come to this, I think with the huge advantage of being an outsider to American constitutional law, as it is traditionally done. So the question then is, how do we figure out whether or not this individual mandate, which says that individuals are required to take out certain forms of health insurance for a certain price if they don't get it from some other source, is in fact constitutional or not? And let me begin in a very modest way by doing something which Jim, like most great modern constitutional commentators, never bothered to do, which is to read you the clause of the Constitution on which the debate is going to take place. And it says, the Congress shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And on this particular text is said to allow the distribution of powers that will cover virtually every single individual in the United States under what is, I think, clearly the most comprehensive piece of social legislation since the Medicare legislation, or perhaps even before that. How does one think about a problem like this? To go through the cases that have decided this means that you have to go through several thousand pages of turgid reasoning. And I think it's probably a little bit easier to try to divide the argument into three parts. One is to sort of look at what the text of the Constitution seems to say, look at the way in which it got interpreted, and then after you understand the interpretation, figure out where you go from here. And so with respect to the original terms, the fact that we had the words foreign trade, had the words Indian tribe, lined up against the words among the several states, suggested early on to Chief Justice Marshall and Gibbons and Ogden that when you're talking about the Commerce Clause, you're talking about intercourse, trade, movement of goods and people, later on, of course, not originally, across state boundary lines. So that essentially they developed a dichotomous way of looking at the world in which those things which were manufactured, mining, and so forth that took place within the states were regarded as local legislation outside the scope of the federal power, and those things which involved the shipment of goods and purposes, communications and so forth across state lines was in fact regarded as subject to the federal power. As one sign of the early narrowness of the constitutional power at the federal government, even if you were talking about commerce that was purely local, like a local bus line that came from an airport, that was beyond the scope of the federal government to regulate. The key case after Gibbons and Ogden is a case called E.C. Knight from 1895. And what this particular case said is that manufacture, mining, and agriculture either precede or follow commerce and therefore should not be regarded as though they were part of it. So essentially, in order to keep the jurisdictional stuff in order, you had this sort of ordinary sequence: before, during, and after. Before and after were reserved to the states. Only the stuff in the middle was subject to federal power. The question is, was this consistently understood? And recently I've looked at a number of important statutes that were passed between 1895 and 1937 when the world changes, and it's clear that they all respect that difference. Let me just mention one of them to you here, which is the Pure Food and Drug Act of 1906. And what it said, in effect, is that the Congress has the power to regulate manufacture so long as it's in the District of Columbia and in the territories. It has no power to regulate manufacture within the several states. And then it gives a long list of when it is that these goods are moving in interstate commerce, they are subject to regulation. And it seems to me that that was a pretty clear understanding. And in fact, in 1918, in a case called Hammer and Degenhardt, it was held quite clearly, and I think quite correctly, is that you could not choke off the lines of interstate commerce by insisting that the only goods that could flow in interstate commerce are those that were not made with child labor within the states. Justice Day, in a 5-4 decision, said if you give them that kind of stranglehold, then in effect there's nobody who cannot accede to the federal jurisdictional power, and so that the whole system of divided sovereignty would come to an end. One of the more notable Harvard Law students is a man named Robert Stern, and first in 1930 was a student, and then later before the Supreme Court, he had a better idea on how to interpret the Commerce Clause, which was to say that anything which took place in local areas, which in fact, when summed up across all sorts of different cases, produced an effect on the goods and services that were shipped in interstate commerce, then those local activities would be, in fact, part of the commerce system. There is no evidence or record of any case relying on this particular theory before we start getting to the Agricultural Adjustment Act of 1938, when the theory was put into practice to essentially allow the federal government, in what is a shameful act, to cartelize the entire agricultural industry on the grounds that if you could not control the ability of a given individual to feed his own cows, his own corn, you could not regulate the total production of these goods. The theory essentially expands the scope of the Commerce Clause 1,000-fold beyond what it was under the earlier reading. And I think it's quite clear if you go through the earlier precedents, this is a terrible departure from the existing thing. So the problem that you face thinking about the subject in more modern times is which of the original constitutions do we use? Do we go back to the one of 1787, which has one very clear vision of the subject, one which on substantive grounds I would argue is better than the one which came in 1942, or you do the others? The modern debate generally takes place on the assumption that since Chief Justice Rehnquist, in a case called Lopez against the United States against Lopez, thought that Wickard and Filburn was indubitably correct, everybody has to start the debate from that premise. His decision was indubitably wrong in terms of his reading of the earlier authorities, and the fact that he has decided this, I think, should not allow us to carry as a normative matter the question of whether or not he answered all the responses. So this becomes the issue. If, in fact, you decide that Wickard and Filburn is not only precedent but sound precedent, it's going to give Professor Tribe and the proponents of the constitutionality an enormous advantage. But if you decide, as I do, that this decision is largely illegitimate and, in fact, highly destructive in its ability to allow the national government to enter into positively antisocial activity, i.e. cartel raising of one kind or another, you will look more skeptically upon efforts to expand. Well, then the question is, can you distinguish this case from that? That is the case with the PPACA from the earlier cases. And the answer is you can, but not necessarily in ways that, as a matter of first principle, one would want to respect. And so the line essentially comes as follows. All the earlier cases, including those that limit the amount of grain that you can grow on your own land, essentially tell individuals that there are certain activities that they can or cannot engage in, that is, or subject to certain conditions. If you want to grow grain, you can only grow so much. What is distinctive about the mandate is that it mandates that you do something even if you hadn't done anything at all. So it's not an effort to regulate activities or activities of commerce, it's an effort to dragoon people into certain kinds of behaviors. And the issue is whether or not this power is consistent with the earlier case. In one sense, the mandate is surely a more modest operation than is the huge agricultural program that you had under the Agricultural Adjustment Acts, but in another sense, it represents a new area for activities that has never been undertaken before. So that in dealing with this particular question, it turns out that the proponents of the constitutionality of the statute have had to deal with what is now sometimes called the broccoli problem, which is if the United States government decided, in order to improve the health of the people of the United States, that everybody ought to eat 3 servings of broccoli, a task which my wife knows I could not discharge in the next 40 years any more than I've done it in the previous 40 years, that statute would surely be constitutional because there is some nexus between eating broccoli and having health. And the issue then is, can you distinguish the mandate from the other side? It's very difficult. And the argument in the end that I think might prevail, although God knows which way this will ultimately come out, is that the misfeasance, nonfeasance line, which comes out of the tort law, and which no matter how you massage it actually has a certain kind of durability, is far clearer than the line between insurance on the one hand and broccoli on the other hand. And if that's going to be the case, and I'll just end up on this notice, the court will say you've gone a bridge too far. You can certainly pass some statute which is designed to deal with this problem, but you have to go back to the beginning. In talking about this, I haven't talked about the taxing questions. I certainly haven't talked about the unconstitutional conditions questions, which will ring a bell to the lawyers and leave everybody else completely muzzled and fuddled. But suffice it to say, as Jim has indicated, this case is a horse race, and if you had asked me this question 2 years ago, before the man who gets the credit for raising these arguments, Randy Barnett, put them forward, nobody thought that the case against this thing was anything other than a laugher. At this point, I think the odds are pretty close to even, which is a stunning reversal about the ways in which things have been done, and I do not know how it will come out because I cannot read the mind of Justice Kennedy. Thank you.
Professor Tribe.
Well, I can't read Tony Kennedy's mind either, and I'm not going to be using a crystal ball. I find when you live by the crystal ball, you have to like to eat not only broccoli but ground glass, and I don't really like either. I, too, start with the original text. Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And one of the things that impressed, I think, Chief Justice Marshall in 1824 was that this word commerce applies to the Indian tribes and to foreign nations as well as to the states. And what I think that quite clearly means is that the power to regulate commerce has always included more than the power to break down trade barriers, because that's not what we do when we regulate commerce with foreign nations or with the Indian tribes. Indeed, it's always meant, as Chief Justice Marshall said in Gibbons versus Ogden in 1824, the power to regulate interactions that involve, in the case of interstate commerce, more states than one. Now, it's true that if we turn back the clock to before the Civil War, turn back the clock to before the New Deal, they wouldn't have expected the Affordable Care Act to be within the contemplation of the commerce power. But then it's not their expectations that became law, it's what they enacted. And what they enacted, I think, has over time come to mean a good deal more than Richard suggests. And I think for a good reason. The reason it's come to mean more is that we have a highly interdependent society and economy, and the attempt to draw bright lines between manufacturing and production and other aspects of commerce really tends to fall apart. And therefore, the court has tried to do something quite different. It's drawn a different line. It said that those economic activities, whether they occur in one state or in several states, that in the aggregate have an impact on interstate commerce are within Congress's power to regulate. The economic activity involved here is the activity of what insurance people call going bare. That is, deciding not to cover yourself with insurance and hoping that when push comes to shove, somebody will pick up the tab. this is the famous free rider problem, and Richard in some of his writings says that we really need tough love to deal with that problem. What we need to do, in the case of someone who doesn't insure herself but shows up in an emergency room, is perhaps just turn her away. But even if that were a wise policy, it's certainly not one that's commanded by the Constitution. And therefore, Congress, to deal with the free rider problem, has said, we are on the one hand going to force insurance companies to cover the people who will presumably not automatically flock to them. That is, we're going to force them to cover people with pre-existing medical conditions, old people, sick people, people who want insurance. But so that they can afford that, we're going to expand the pool and make people who would rather not pay for their own insurance even when they can afford it, we're going to make them either buy it, or if they don't buy it, we're going to increase their income tax liability by a measurable amount, which is why this is an exercise of the taxing power as well as of the commerce power. It's really very different from making people eat broccoli or making people eat asparagus, these silly examples. Because the fact is that if I want, I can spend my entire life and never eat broccoli. And that may well be my choice. What you cannot do is spend your entire life and never consume medical care. That's something that, given the nature of human life, everybody has to consume at one time or another. So the decision to be a consumer of medical care but not insure yourself against it is a quintessentially economic decision. And when Congress decides that that kind of economic activity, and it is activity, it's not inactivity, that sort of economic activity has important interstate effects, it's understandable that Congress would reach out and regulate it. Now, when Richard mentions the case that he thinks is one where the court clearly got it right, so the case of Hammer versus Dagenhart, it's a case that I also want to talk about. It's a case where Congress said that we're going to prevent the transportation in interstate commerce of goods manufactured by child labor. And there was no question that this was interstate trade. There's also no question that the reason Congress was regulating it was the famous race to the bottom, the fear that if some states allow the exploitation of 11 and 12-year-old kids, and other states say that you can't hire someone under the age of 14 or 15, the net result will be that businesses will flock to the places where they can hire younger kids. Richard says it was just right that the court struck that down. But the way it struck it down was to say that it's not up to Congress to decide that human dignity or morality should be part of the picture. In fact, the reasoning of that opinion by Justice Day, an opinion that I think Richard thinks hit the nail on the head, relied very much on basically misquoting the Constitution. Justice Day said that the Constitution reserves to the states all those powers that are not expressly delegated to the national government. Well, that's what the Articles of Confederation had said. But the Constitution deliberately was broader. It said that the national government has those powers that are not reserved to the states. That is, the states have the reserved powers that are not delegated to the national government, not the powers that are not expressly delegated. And John Marshall in 1819 made a big deal out of that difference. That's when he upheld the power, even though it was not expressed in the Constitution, to create a national bank. He said that the Articles of Confederation were too narrow and that Congress has those powers which are reasonably related to those that are delegated. It's on that ground that Congress has the power to impose this mandate. Now, the mandate is something that Randy Barnett, to whom Richard has referred, objects on the ground that it's an invasion of personal autonomy. And I think that Jim said that we were not going to be talking about that, but that's the nub of the objection. The real objection is making someone buy something he doesn't want to buy is a terrible invasion. Well, point one, if that were true, it would be just as terrible if it were done by the states as by the national government. That's a libertarian objection, and it's one that's so weak in terms of existing law that nobody has made it in any of these challenges. Number two, the idea that you're forced to buy something here is simply a caricature. It's not as though the law is dragging you into an insurance company's office and saying, here, sign on the dotted line. They're just saying that because you're going to be imposing serious burdens on the system, either on other insurance buyers because of higher premiums or on taxpayers, if you choose to go bare, that is, take the risk that when you need medical care, you will be able to pay for it, or someone else will pick up the tab. Because of that, we're going to increase your income tax liability an appropriate amount if you don't buy the insurance when you can afford it. That is an exercise of the tax power and provides an alternative basis for upholding this law. In any event, it's not true that you are somehow compelled into an involuntary contract. So this is not an extraordinary exercise of government power. It's simply a fairly conventional exercise, though it's part of an enormous overhaul of the healthcare system. Now, Richard may be right that if there were a smaller regulatory footprint for the national government, if we allowed free markets to work better, we would be, in a utilitarian sense, better off. I'm not here to argue the policy of Obamacare. There are many aspects of that legislation that I don't think are all that brilliant. But the question is not whether it's wise policy. The question is whether, in terms of what our Constitution was from the beginning and has elaborately become over time, it is consistent with the Constitution. And that's a very different question. To suggest that any of us, whether schooled in the Chicago School of Law and Economics or at Harvard, should be able to impose our judgment of wise policy on an economic measure of this kind strikes me as lacking in an appropriate degree of constitutional humility. When Richard says we ought to roll things back, realize that his point of view, and it's a perfectly respectable, coherent one, would mean invalidating Social Security, Medicare, Medicaid, the National Labor Relations Act, most of what we've gotten used to in the past 70 years. Now, I think Richard would say, great, that's great. But it seems to me that some degree of respect for what generations have come to formulate and some degree of humility about one's own brilliance is an appropriate thing when one is dealing with something as delicate as the national policy of the United States. It's on that ground that I think this law is perfectly constitutional.
We're going to give each participant a chance at rebuttal, and then I'll ask some questions and then open it up to the audience. So,
It should take
Professor
more
Epstein.
than 5 minutes, but let me see if I can do it. First of all, let's start with the original text on Constitution. These are quoted by Professor Tribe, in which he talks about this, as Marshall talks about that commercial intercourse extended to all activity having interstate impact, however indirect. Acting under the Commerce Clause, Congress could legislate with respect to all commerce that concerns more states than one. The actual sentence reads very differently. It says, comprehensive as the word commerce may be, it is restricted to that commerce which involves more state than one, and that purely local commerce is no part. When Marshall wrote this, the next sentence was, a state inspection law at the end of a journey was beyond the power of Congress to contramand. So what he meant is that on that interstate journey, it was plenary and dominant, but essentially he reserved a huge amount of local discretion and did so for the very simple reason that he understood, if you read the Commerce Clause the way Professor Tribe reads it, slavery is now a subject in 1919 or 1892 as being a matter for federal regulation, which nobody thought. As to Hammer and Dagenhart, I mumbled something earlier about the doctrine of unconstitutional conditions. And the whole point is that in addition to the text, there is this elaborate doctrine which says that whenever the state acts in exertion of a monopoly power, what it cannot do is to alter the balance between it and anybody else. So it's not the child labor law which is the sole source. Suppose Congress said, and let me get the statute right. It didn't say that goods shipped as made with child labor could be shipped into interstate commerce. It said that any plant which had any portion of it which made child labor could not ship any goods, even those goods that weren't made with child labor, into interstate commerce. That's a stranglehold. That's a question of monopoly power being extended so that you can't stop it. And if we said, for example, that any state which respects the freedom of speech and of conscience cannot have its manufacturers ship good in interstate commerce, that would only regulate the flow in interstate commerce, but everybody else would think otherwise. The nature of the condition, it's not just child labor, it's any and all conditions that do it. And it's not necessarily a preliminary, basically a prisoner's dilemma. You have to decide whether it's going up or down. And there's some very good work recently on the whole child labor movement, which suggests that really aggressive child labor laws do far more harm than they good, and that if you really care about human dignity and so forth, you don't want to drive children to begging, prostitution. You don't want parents to break their limbs because they can't work in some kind of a factory. I would not on this issue even begin to concede the moral ground. It's exactly the opposite as far as I'm concerned. Prisoner's dilemma games, all competition is a prisoner's dilemma game. Until you know the resource effects, you can't say that the prisoner's dilemma game is either something which is good or something that is bad. Moving forward, the question is, this is still a very tough thing, how do we deal with this? Now, Larry was right to say there is always the tough love stuff, and there is a statute called EMTALA which says no tough love. Somebody comes to the emergency room, you have to let them in. But that's not what my proposal necessarily says. Go to it the other way. There are two things going on here, and Larry is basically trying to ride two horses into the night simultaneously, but they're pulling in different directions. One of them is these guys turn out to be a free rider. Well, if you want to stop free riding, I could tell you how to do it. Say to each particular person, you must take out an insurance policy, and the government will mandate that you do so, and it has to cover the expected cost of you so that you do not have to put any drains on the system. That would, of course, be a complete disaster, because the real point of this thing is not to stop free riding, it's to encourage cross-subsidy. We're trying to say to you, you have to pay more money than it's going to cost you to deal with your particular health care problem, so we get other people, they could pay less when they do it. And you get a giant cross-subsidy mill, which turns out to be deeply unstable in any economic sense, hard to price, hard to maintain, and so forth. So if you can realize that lesser means are going to be able to handle the entire question of the free rider, then in effect you cannot use the free rider argument to justify the true reason for this particular situation, which is an elaborate set of cross-subsidies that exist as between individuals. So when you look at this whole thing taken together, what it's really trying to do essentially is to socially engineer a large situation in which unwilling subjects are going to be forced through the commerce power to subsidize everybody else. Now, Larry mentioned, and I'll just end on this point, that this argument is so hopeless that nobody would be prepared to raise the individual autonomy argument. Well, almost nobody would be prepared to raise the individual autonomy argument, but let me tell you why I want to raise it. One of the things that's so striking when you actually look at constitutional history is individual rights and federal power questions seem to occupy completely different corners of the world. But the thing that links them together is something which is not in the constitutional text, but like the doctrine of unconstitutional conditions, has to be read in, and that's the federal police power. And it turns out that when you look at Commerce Clause cases, there are police power limitations on what various government agencies can and cannot do. And so it is with respect to individual liberties. So the question would be, how broadly do we read the police power? And its technical terms is it covers those matters which deal with the health, safety, general welfare, and morals of the population at large. There's a very good book by one of my colleagues called The People's Choice, in which he goes through all the 19th century, Bill Novak is his name, all the 19th century justifications that were used to deal with legislation. You could control firecrackers, you could control nuisances, you could control fire of all sorts and description. You look through that book and you try to find any instance in which 19th century police power was used to force people to take out insurance or to do any other thing, it turns out to be completely empty. So my own view is that the tragedy of the 1937 revolution which has created this immense expansion of power at the state and local government, is that not only did it extend the commerce power beyond all reason, but it also extended the state police power beyond all reason. Larry is surely correct when he says that American constitutional law makes these arguments untenable. My reply as a normative matter is that's one of the reasons why the law in its current form is so awful. And if you're trying to figure out what the judiciary contributed to the current economic malaise, suffice it to say that the ability to have massive levels of redistribution at both the federal and at the state level without any kind of limitations on what the government can do is in fact now, when we push to the limits, the source of our current decline. If there's ever a time when we have to rethink the way in which we work our constitutional doctrine, this is it. The first time we did it in 1937, they made a complete mess of everything because they had no idea what the sources of the problem are. And I fear today we still don't understand why it is that there's government malaise. And if we continue and support the PPACA, we will basically consign ourselves to a healthcare system that nobody will be proud of. Thank you.
Professor Tribe, and I'll give you a couple more minutes because Richard ran over a little bit as well.
You know, thanks. I don't often find myself riding two horses simultaneously. It feels a little bit uncomfortable. I also don't often find myself relying heavily on Justice Scalia, but I think I will for present purposes. Because I think he makes a good point when he says that legislatures often mess things up. I think Richard may be right in describing much of the mess that's been created in the last 5 or 6 decades. But he says, I would rather be sort of governed by the legislature, messy though it is, than by 9 justices of the United States Supreme Court, even though many of them may be as bright as he is. The idea that the Supreme Court would be able to decide which kinds of cross-subsidies are appropriate and which are not, which kinds of free rides it's appropriate for legislatures to try to prevent people from taking and which not, scares the hell out of me. That's why the Supreme Court, I think, has found itself in the awkward position of saying that, dysfunctional though it may be, if Congress decides, in what they sometimes oddly call its wisdom, that it's going to ban either the local consumption of wheat, as in the Wickard v. Filburn case in 1942, or of weed, as in the case of Rach v. Gonzalez in 2005, so be it. Now, weed was an example. California thought that as long as there's a careful, medically controlled exemption, the merely local growing and consumption of marijuana ought to be okay for people for medical purposes. But Congress had a comprehensive scheme of regulating the production and consumption of marijuana, and it was understandable that there would be some difficulty in enforcing that whole scheme if states like California could have exceptions. And so Justice Scalia, writing a separate concurring opinion in Gonzalez v. Raich, said that it's within Congress's power to control the purely local consumption of marijuana, even in a state that carefully licenses and controls it for medical purposes. Now, in the ideal world, I'd be a bit more of a libertarian. I don't like government telling people which drugs they can consume. But when you take a broader look, when you look at the interstate and international market in drugs, there are clearly side effects, there are clearly externalities, there are people that are hurt, there are people that are killed. And so if Congress decides that it's going to have a comprehensive regulatory system, one of the corollaries of that, under the necessary and proper clause, is that if it's rationally related to that system, to say that you can't grow and consume your own marijuana in California, so be it. That's really what's happening here. That is, Congress is deciding on, I think, perfectly rational grounds that, left to their own devices, insurance companies wouldn't cover people who are very old, who are sick, who have pre-existing conditions. We've got to make them do that. But to prevent them from going broke, we also have to make sure that the pool of people includes the young, the healthy, who wouldn't voluntarily buy insurance We're not going to drag them to an insurance company to make them pay and to make them sign a contract, but we're going to increase their tax liability if they don't. It's a perfectly rational scheme. It doesn't control things that have no impact on a multi-billion-dollar interstate economy. If Congress has the power to regulate those economic activities, like the activity of spending your life uninsured and consuming medical care for which you may end up not paying, if it has that power, then it's hard to see why this law is not constitutional. Most of what Richard has said, and what I understand drew some applause, was if I were king of the universe, I would design it better. Well, maybe Richard would, but is it going to be Richard, or is it going to be Anthony Kennedy, or is it going to be Sotomayor or Kagan or Breyer who's going to be designing the system? I don't think Congress is a great institution, but it's democracy. That's what we've got. Government of the people, by the people, for the people. Now, it's true that we as individuals have certain fundamental human rights, and it's tempting to think that medical care touches something intimate and personal. That's why I agree when the Supreme Court says in a case like Cruzan against Missouri that if you don't want to receive medical care, the government typically can't force you to receive it. There are exceptions. You can be vaccinated to prevent the spread of contagious disease, but you have a right not to be forced to accept medical care. But that doesn't include a right to receive medical care at some point in your life and not pay for it. And a scheme that is designed to increase the probability that you will have paid for it by being insured or paying a higher tax simply respects that principle. It does not invade the integrity of the human body. If there's anything unique about medical care, it's that unlike most things, we can make a clear prediction about it, and that's everybody's going to need it at some point. Because everybody's going to need it, we are all consumers at some point in our lives of medical care. Because we're all consumers of medical care, the decision not to purchase insurance is an economic decision. It's very unlike the decisions the Supreme Court said Congress could not control in the cases that Richard says made no sense. They actually made sense to me. Congress said in the Gun-Free School Zones Act that possessing a gun near a school is a federal crime. Now, there's nothing economic about possessing a gun near a school. So the fact that gun possession near schools in the aggregate might affect the national economy, the court said, doesn't cut it. Congress cannot aggregate things that are not economic in order to extend the commerce power, because then everything we do could be controlled by Congress under the commerce power. But there's a fundamental difference between the non-economic activity of having a gun near a school and the economic activity of deciding to finance your health and your health expenses off the public fisc, showing up someday in an emergency room and not being insured. That's an economic decision. It's a very clear, bright line, and that's the limiting principle that will enable the Supreme Court, if it upholds this law, not suddenly to allow Congress, through a national police power, to engulf all human activity. It's what I hope the court will do.
Thank you, Professor. Before I open it to our audience, I've got one question for each panelist, and I'm going to start with Professor Epstein, since he was didn't speak last, and I want to develop the taxing power question that you haven't addressed, because these issues, the tax power is clearly broad under the 16th Amendment, the Income Tax Amendment, and as I would read the Income Tax Amendment, it would seem to be perfectly fine if Congress were to enact, say, a direct tax. A direct tax is in the original Constitution, and charge everyone a tax, and then give a refundable tax credit to everyone who had an insurance policy that qualified. If that's the case, is Professor Tribe right that you can think about this as a tax? I want to point out to the audience that these are separate issues being considered by the courts, and only 2 of the judges on the Fourth Circuit panel of 3 judges actually bought this tax argument. So most of the judges who consider this haven't bought it. Why is that, Professor Epstein, or do do you concede that this is something we can talk about as a tax power that Professor Tribe's arguing? And if not, why not? Because it's a separate clause of the Constitution than the commerce regulatory clause.
Oh, I agree with that. Let me just first read the 16th Amendment. It always helps. The Congress shall have the power to lay and collect taxes on incomes from whatever source derived without apportionment amongst the several states and without regard to any census or enumeration. This is hardly something which changes the scope and the power of the tax. What it does is it eliminates a provision in the original Constitution whereby, in an effort to prevent redistribution of wealth across states, you could not impose the same tax on value in Virginia that you did in Delaware for a common federal expense if it turned out that the Virginians would have to pay twice as much as the Delawareans, and it was an effort to try to equalize. So then you have to do is you have to go back to the power of the Constitution is to lay and collect taxes for the general welfare and the common defense, is what is said. And again, there's a narrow and a broad definition of these powers. I'm a passionate believer in the narrow definition, no surprise, and which says that you read general welfare and common defense in pari, and it means that this is an effort to try and use taxation to handle the collective action of public goods problem, which is to provide those things which voluntary markets cannot assemble because of high transactions costs. And if common defense is a classic public good, you don't want to read general welfare as something which says if lots of people benefit from this kind of thing, we're going to treat it as a general welfare proposition if it turns out that you can't meet the requirement of a public good, which is namely that to impose or to give the benefit to one person, you necessarily have to give it to all, and it's an effort to offset that you have the power. The other reason why in this particular case I think the courts came down with this is that there are procedures by which you enact taxes. And in the original deliberations, in order to avoid some of the committee reviews that would be given to a tax, what everybody said is that this is not a revenue measure, this is a penalty. And so they purported to move under some other power. After they get the thing through, they say, oh, this is not a penalty, this is a tax, and we can start to do it. And so the reason was a kind of estoppel. And the argument is one on a process level, which makes perfectly good sense. If, in fact, there are processes that you have to meet in order to get taxes, not to follow the processes and then to recharacterize what you're going to do is going to make a mockery of the internal structural features inside the government. So there is, in that particular regard, a certain difficulty. The second point about taxation is, in fact, is that we know here the question is, what counts as a tax? So let's put it the following way. Suppose what we said is, look, we need to subsidize people over 65, and we got to get that from people under 35. So we hereby agree to tax people under 35 a certain amount, because they're the only ones who are going to subsidize, and pay people with 65 a sum. What happens is the political factions from those turns are really quite violent. What happens if you're going to try to do this as a serious tax? If you levy it on income, you're not going to be able to target one group of the population or another. And Professor Tribe, if you remember, he talked about the learned Justice Scalia talking about these wonderful democratic institutions. But one of the things, of course, that even he understands is that when you start to allow these kinds of transfer payments, you're going to get yourself into trouble. So he said if you want to have subsidies, for example, for rent control for poor people, in a case called Pinnell, he says you can do that, but you can only do it if you're going to tax the public at large, because the last thing you want to do is to have everybody in the United States act like Leo DeRocha. Let you and him fight. That is, I'm going to vote the tax on these guys, but I'm not going to have to pay it. They're going to get the benefit from this thing because it includes faction. And there's no exaltation of a democratic system that doesn't take into account the public choice. In fact, the great successes under the Constitution, like the protections of freedom of speech and the Dormant Commerce Clause, have all gone in the teeth of popular democracy. All have recognized these kinds of abuses. All have applied strict scrutiny. So that the question that Professor Tribe has to answer is why is it that he is a great champion of the democratic principle when huge transfers are involved here, when he knows that the Supreme Court, rightly in my view, said that the progressive tax was unconstitutional insofar as it applied to newspapers. You can't tax the rich to subsidize the poor. It seems to me that that's the right principle. We do not have a constitution of complete deference, and if you construe the taxing power the way Professor Tribe does, It leaves for much too much political abuse. And into the equation, you have to factor that Congress is in low repute precisely because the faction game, which our friend James Madison wondered about, is given absolute carte blanche under the current way in which the court construes its powers.
Thank you, Professor Epstein. I'm going to allow Professor Tribe to respond to Professor Epstein's argument there, and then I've got a short question as well.
Well, it's clearly the case that if a tax is imposed selectively on newspapers based on how many pages they print, which is what that case involved, that's a burden on the freedom of the press. But nothing in the court's history, and nothing I've ever read in the history of the Constitution, suggests that a general tax is subject to some suspicious reaction under the Constitution, subject to strict scrutiny, because some rich people end up having to pay more than poor people. If I heard Richard correctly, an implication of what he's saying is that progressive taxation is unconstitutional.
Correct.
That's fine, but it would take more than the 2 or 3 minutes I have left to explain the 45 reasons why I think that's untenable. I want to talk about the narrower points that Richard made. The most important of them, I think, is the idea that this somehow snuck through the legislative process. The fact that there was a president who made it a campaign pledge to do basically this and won. The fact that it was as ugly as sin as the sausage was being made in public prevents one from making, I think, any serious argument that there was no political accountability here. The fact is that, well, look, the word tax appears in this statute over 40 times. People didn't know it was a tax? It's codified in the, well, that's a big deal. If we struck down laws that nobody read, as Justice Rehnquist said at one point, all of our laws would be struck down.
Now you're talking.
It's codified in the Internal Revenue Code. The penalty is calculated by reference to household income. It's enforced like other taxes by the Secretary of the Treasury through civil collection. Of course this was a tax. The fact that for various strategic reasons, lawyers didn't want to argue that is a problem. One of the problems is the Solicitor General's office wanted a quick decision. How do you get a quick decision? You pretend it's not a tax. Because if it's a tax, the AIA, the Anti-Injunction Act, prevents you from getting a decision before someone has actually been subjected to a penalty, which won't happen until 2014. That's why the Fourth Circuit said, we're not going to reach the constitutional issue because this is an attempt to prevent the collection of a tax. So it was not in the interest of the Solicitor General's office, which wanted a quick decision. I'm not even sure why they wanted a quick decision, but they thought they had a favorable panel to admit that it was a tax. So it seems to me that this is obviously a tax, and the idea that we could basically hold the entire Internal Revenue Code unconstitutional while we are, which I'm sure Richard would love, while we are reviewing the Affordable Care Act, I think is just not serious.
Well, just to follow up on that a little bit, and then my question, wasn't it though the case? I mean, you're saying that this was a campaign promise, but I believe that President Obama during the campaign was opposing the individual mandate. It may be incorrect.
No, that's right. He was opposing the mandate.
And I also believe that he and most of the congressional people during the debates were arguing that this in fact was not a tax at the time. Is that?
It's true that the political arguments went both ways. Hillary Clinton wanted a mandate. Obama didn't. Then Obama concluded we needed a mandate. But the way this was working, I mean, there were all sorts of parts of it that had to be collected as a tax in any event. But I don't think that we can make the constitutionality of a measure depend on an assessment of what the PR firms are doing in selling it.
Right. Well, just getting back to the text before I open up for audience questions, because we started with the text, I think Professor Epstein's right, and you've gone to the text as well. Regulate commerce among the tribes, the foreign nations, and among the states. Well, you clearly wouldn't argue that this clause would allow the Congress to force people in France to buy private health insurance, would you? And if not, how do you distinguish it, since it's the exact same clause of the Constitution?
Well, there are principles about extraterritoriality and about the power of the long arm of the United States to reach Sarkozy that I think are quite separate. Now, my point is that the word commerce can't mean one thing when you're talking about commerce with the Indian tribes and another thing when you're talking about commerce among the several states. So commerce, I think, clearly means more than just trade between, and the power to regulate commerce means more than the power to remove trade barriers. But I'm not pretending, and I wouldn't pretend, that if we turn the clock back to the founding, that the founders thought that this kind of power existed. I don't think that they did. Obviously, they made profound compromises with slavery, and they didn't think that they were giving Congress the power to abolish slave labor. But I don't think we're bound by the original expectations of the founders. I think that we have a very long history, and we have the clear text to deal with.
Great. I want to open up to audience questions. Let's see, right over here. Thank you.
Professor Tribe, you drew
You could identify yourself.
Forbes Tuttle. I write this place a check, I guess. That's why I'm here.
Stand up, I think, will make it easier.
Professor Tribe, you drew a bright line between people that have insurance, health insurance, and free riders that are relying upon someone else to pay for it. Certainly there's a third group of people, and that would be those that choose not to buy insurance but can clearly afford their own health care, paying out of pocket. And so I'm missing where the bright line falls there.
Right. There's certainly, as the courts conceded, there will be a number of people who choose not to buy it who, when push comes to shove, will be able to pay. But the Supreme Court in the marijuana case, and I think quite rightly said, that the fact that a law is somewhat over-inclusive doesn't make it unconstitutional as an exercise of the commerce power. That is, if you could predict in advance that all the people who don't buy insurance will be fully funded personally down the line 20, 30 years later when they need long-term care or when they show up at a hospital in a coma, then you would be able to exempt them from the law as people with a religious objection are exempted. But you can't predict that. And statistically, a very large number of people who choose not to insure at a later point are going to pose a public problem. And to deal with that problem, admittedly not with scientific precision, but in a rational way, Congress has decided to treat these people as posing a potential free rider problem.
Can I answer?
Certainly,
Yeah,
Professor Epstein.
look, I mean, you're talking about probably a majority of people who have other forms of funding in terms of either self-help or ability to get access from family, friends, loans, or whatever it is. So it's a very large overcompensation. And the same thing true is Reich. I mean, what Larry has done is he's talked about all the needs for government. He hasn't talked about the incredible human suffering that takes place when people who need medical marijuana can't get it. He talks about the wonderful autonomy that allows you to refuse medical treatment, but he won't mention the autonomy that allows you to take it. So there's cases like Abigail Alliance where this poor desperate child died of cancer because nobody would allow her to get a drug given the FDA oversight and so forth. And the question is whether there's a constitutional right to receive medical treatment has been flatly denied by the court. And I think I cannot conceive of the democratic political issue that has to work in these cases. And let me just mention, we had more medical progress, more alleviation of human suffering before the FDA had the power to oversee the creation of new drugs than we did afterwards. Just to give you one illustration, it took a grand total of less than 3 years to get the diabetes insulin drug into market from the time it was a bright idea before the bench. You couldn't do it in 20 years today. So I just don't understand why it is that we have to make this argument that Congress always knows best when that collection of morons on most of these issues knows absolutely nothing but partisan politics driven by an institution which is so rigid, when we've had historical experience where the performance is basically as follows. The more power we have to the FDA, all other things controlled, the less level of medical innovation and the greater level of human suffering. I just don't understand why there's a
Richard,
constitutional
you're
imperative.
preaching to the converted here. I've written about why I believe that the Constitution both gives people a right to medical attention and medical care to alleviate suffering, sometimes even to bring about death when their suffering is terminal and
So
and
you
horrible.
would agree with
So
Ginsburg
well,
on Abigail Alliance? I mean,
Yeah,
I
I
want
think-
your voice on this.
yeah, I
regard
do.
it as absolute. I mean,
I
you
do
say-
think so, but let's not lose track of
Say
what the
yes.
issue is. The issue is not whether sometimes. I mean, look, sometimes we have a right to refuse unwanted medical care. We may be unwise in refusing it, but we have that right. On other occasions, as in Abigail Alliance, I think we have a right not to be denied available medical care, and I believe that's true in reproductive care as well as other areas, not to be denied available medical care because of some generally valid, overarching bureaucratic rule. But the question I was focused on in the Raich case, Gonzalez v. Raich, isn't whether there should be a constitutional right to get medical marijuana in some instances. I believe there actually should be. But rather whether Congress's affirmative powers, which are of course subject to limitations of individual human rights in terms of speech and in terms of bodily autonomy, whether the affirmative powers of Congress should stop at the border of an individual state in a nation that is as economically interdependent as ours. I think Congress has the affirmative power to ban the use of certain substances, but there may be overriding personal liberties that come into play, and I'm certainly willing to argue with respect to medical marijuana and other medications that those overriding liberties trump Congress's affirmative rights. But I do not think you have an overriding liberty to go without insurance. That's quite different. That is, the idea that the liberty people have to take care of their own bodies sort of extends to the way they choose to finance their health care when that has such massive impact on the nation is an idea that I think is one step too far.
I dissent.
All right, right here, sir. And please wait for the mic.
My name is David Schimmel. Professor Tribe, you said repeatedly that everyone inevitably is going to need medical care in their life, and that seemed to be very important to your argument. But in light of the fact that there is a Medicare program, which means that it covers virtually everybody over the age of 65, you'd have to modify that to say you're inevitably going to need medical care up until the age of 65.
Yeah, well, that's why that's part of the law.
Okay.
The
Well,
law
let me-
exempts you if you are covered by
No,
Medicare,
I understand.
Medicaid.
I understand. But your argument is,
Yeah.
if in fact you can make the argument that not everyone, in fact many people, may not need medical care below the age of 65, and to the extent they may need it, it may not be very expensive and elaborate, depending on their circumstances, you're now going a lot further to rationalize why everyone has to be included and be penalized if they're not, because it's not necessarily clear any longer that everybody under that age is necessarily, a large number of them may not necessarily need medical care that they couldn't consider affordable like any other good.
No, I think that's a very good point. One of the reasons that President Obama during the campaign didn't want an individual mandate is that he didn't agree with the actuarial studies about how many people were likely at the time that they needed medical care not to be covered by some other program like Medicare. There are studies going both ways on that, about how large that problem will be. But when Congress decides that it's going to believe the studies that say the problem will be in the multi-billion-dollar area and not trivial, fashioning a form of judicial review that would allow courts to say, no, we don't think that the Congressional Budget Office is accurate in these figures. We're going to second-guess that office. That's very troublesome. It would require, in the economic area, developing a degree of judicial review and scrutiny, which I know that Richard would favor, but which I'm troubled by, of the sort that we have with respect to speech, religion, and a few limited areas like bodily integrity. Is the moment... What's you're laughing, Richard?
No, I'm about to answer, but you
okay,
finish.
go ahead. I mean, it seems to me that to have that degree of scrutiny over the entire universe of socioeconomic legislation, state and federal, would be a large transfer of power to an unelected, unrepresentative branch, which troubles me. I think it's much better to have the independent judiciary have that kind of power over limited areas of personal integrity and personal autonomy.
I disagree. Let me go back to the constitutional history. The United States, in the period before 1944, a case called Hope Natural Gas, had extensive review of the most complicated rate-making procedures that you could possibly imagine with respect to very difficult pricing issues having to do with natural monopoly and the provision of electricity, gas, and so forth, joint costs, and so on. I actually had to read this when I worked for a while on the Durbin Amendment, and it turns out that these guys were tremendously sophisticated in the way in which they worked these things. It just wasn't a question of subjectivity one way or another. The great curse of the rational basis test, which says that this is too difficult for any court to do, is in effect that it induces courts to become stupid so they don't have to do it. In those eras when there was strict scrutiny over rate making, as there was, it turns out if you look back at those decisions, even in the light of modern economic theory, those characters were really extremely good at what they did. And in fact, in this particular situation, there will be a rate-making challenge to this statute. There has to be, because the medical loss ratios that they put in at 15% are so utterly actuarially insane that they will be challenged on taking grounds on an as-applied basis, and we will have to look at it. When you look at the mandates with respect to what you have to supply in order to get your minimum coverage and so forth, these things are so wildly overpriced relative to the income that they too will have to be challenged. So the question is not whether you're going to be able to stay out of this thing. The only way you'll be able to do that is to say, since we don't do anything, you can do everything. And again, the Constitution is not just a democratic will-making law machine. It's a faction device to control it. And courts are an essential role to play in that. They've done it in the past. I'm very hard-pressed to find, and this is a period I actually study, anything including the labor regulations before 1935, where if you actually knew what the subject matter was about, that there were serious miscarriages of justice. And in fact, the regime under Lochner in New York is infinitely more sophisticated in terms of what it does than the regime that developed after you approved the National Labor Relations Act, which was struck down in two forms in 1908 and 1914. I mean, it's not Larry acts as though you could never have done this. And you have done it, and you did it well. And so the paean to popular democracy is, I think, at very strong odds with our much more complicated constitutional traditions.
It's like baptism. I mean, when somebody says, do you believe in it? And the answer is, hell yes, I've seen it done.
Larry, I have. I mean,
I've seen it done too.
And
I have a different assessment from Richard about how wonderful the Lochner era really was. I do think it's wrong to demonize and caricature it. But I think to say that when the Supreme Court of the United States struck down maximum hour laws, minimum wage laws, laws protecting workers from exploitation in various ways, struck down laws saying you can't hire 14-year-olds. I'm unwilling to gamble that it's a great thing to say the market will take care of everything. I think the invisible hand has its limitations. And I think because it has its limitations, I'm unwilling to simply say that because in certain technical areas like rate making, we can devise formulas for reviewing rates for reasonableness, that it follows that we can take the entire panoply of the social safety net and subject that to careful judicial scrutiny and strike it down when we think it's unreasonable.
Okay, look, that's wrong. I mean, you look at it historically. Lochner was not a worker protection situation. It was an anti-competitive statute for protection of union laborers. Take a key statute, the workman's compensation statutes, right? Justice Pitney, who wrote in Adair and struck down collective bargaining, wrote a very strong opinion in White in New York Central Railroad where he upheld the workman's compensation laws, right? So the challenge to you is not to talk about this in the abstract. It's to name a case where you think the result is wrong, in which there's overreaching, which I will then promptly defend.
Well,
I
think we could get into that, and we could go through lots of cases, and I think our audience, however, has gotten a very good picture of two very different visions of constitutional law, and which of those visions is going to actually wind up victorious in the Supreme Court, only time will tell. I don't think we'll get Richard's full vision at the Supreme Court level, but we may, on the limited basis, get it in terms of at least this individual mandate provision. Again, we don't know what Tony Kennedy's thinking, and we don't know what, I honestly don't know what several of the justices will think on this. I've got a pretty good idea about five of them. Four on Professor Tribe's side and one on Professor Epstein's side. The other ones in the middle, I'm not sure what they'll do. We will see before too long. Okay. Thank you all for coming.
Great. Wonderful.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.